Hello everybody, thank you very much for attending this lecture. My name is Toshiyuki Kono. I teach private international law at Kyushu University in Fukuoka, Japan. Today I'm very pleased to have this opportunity to speak about the private international law in Japan to you. Japan introduced the Western legal system at the end of the 19th century, and private international law was a part of it. Actually, the first legislation of private international law, called as hore in Japanese, was promulgated in 1898. It was drafted under a strong influence of German law and its scholarship. This old law was not amended for almost 100 years. There were some minor amendments, but the first major amendment was made in 1989. But that was the amendment of the part of international family law. And then 2 years ago, the remaining important parts, namely contract and tort, were also amended, and even the title of the law was changed. So the Code of Private International Law in Japan is now called as Act on General Rules on Application of Laws. Well, I said that the most recent reform dealt with reform of the tort and contract laws, but today I would like to concentrate on the contract. The principle of private international law to international contract is the principle of party autonomy. So the parties of the contract could choose an applicable law, and this law is not necessarily be related to the contractual substance. For example, a Korean and the Japanese companies could agree upon the applicability of English law to their contract. Well, in most of the business contracts, there are clauses on applicable law. And this is actually clearly provided for in Article 7 of the new law. But at the same time, there are cases where there is no agreement on applicable law, or the parties simply fail to reach an agreement. And in this case, the judge is expected, taking various factors in each case into consideration, find a law which is deemed as applicable law with implied intention of the parties. If it is not easy for a judge to find this law, that there was a default rule under the old private international law. That was the law of the place of the contract. But this default rule, for the case of the absence of parties' agreement, was changed, and now we have a new rule for that. The reason of this change is the fact that the place of the contract depends upon too much ad hoc situations. The place of contract could be a place where for the both parties it's convenientist. So they mean that the place of contract is not necessarily the law of the contracts which the parties really want to apply. Therefore, the new law introduced the following connecting factor, namely the most closely connected law. Of course, the judge is expected to find where or which place has this most closely connected relationship to the contract. Japanese law provides a new mechanism to facilitate, to find the most closely connected law. This is namely the concept of characteristic performance. This is introduced under the strong influence of EU regulation on applicable law, especially Rome I regulation, so-called. Characteristic performance means the performance of the contract which is different from the payment. So if you buy some products, then your payment is not the characteristic performance, but the delivery of this product is the characteristic performance. So according to Article 8, Paragraph 2 of the new law, the law of the party who does this characteristic performance has a habitual residence. The law of the party's habitual residence who does this characteristic performance is deemed as the most closely connected law. Well, I said deemed, but maybe exactly speaking I have to correct. It is presumed, so that the judge still has possibilities to determine a different law as applicable from the law of such parties' habitual residence. This is the more accurate explanation. Besides this default rule, the new Japanese private international law introduced two important provisions. One is for the consumer contract, the other is for labor contract. In both fields, the concept is to provide more protection to the weaker contractual party. The new law introduced the mechanism to provide more protection as follows. The principle is the same. The parties can agree upon applicable law. But due to the difference of the power balance, the consumer or employee may be forced to accept a law which is not favorable to them. In such case, the consumer or the employee can make a declaration that the law of his or her habitual residence should be applied in a case of consumer law, a consumer contract. In a case of a labor contract, the employee could declare that the law of the most closely related to the contract should be applied. With this declaration, even the mandatory rules of these laws can be applied, replacing the originally agreed applicable law. So let me concentrate on consumer contract. I provide you with 3 simple cases. And let's examine what would happen under the new law. The first case, a tourist comes from Peru to Japan and he buys some products from a company. And he finds out that the products are very problematic, and he feels that he was not well informed, and he is very unhappy with the product. So to obtain more protection as a consumer, he declares that the Peruvian law should be applied, because he found out that the applicable law in the contract between him and the company was a law somewhere in Africa. Could he obtain the protection with his declaration? This is the first case. My answer is unfortunately no. You may wonder why. Because he made this declaration and the law says that the protection of his habitual residence is applicable. It is very true. However, there's an exception. Consumer like him, namely the consumer who voluntarily comes to the place of the provider, is not protected. The purpose is for the company or for the provider, it would be very confusing, it would be very difficult to identify from where this client comes and what law would be applicable at the end of the day. So to protect the very sound business, active consumer like him who voluntarily comes to the place is not protected. However, if he got strong incentive to come to Japan through very specific advertisement, for example, he receives mail from a particular company, for example. With this kind of incentives, he decided to come to Japan and to buy the product. In this case, he will be protected. The second case, if somebody buys products in Peru and the products were delivered from Japan, the products had a very bad quality. So the consumer is not happy at all. and he decided to sue the company in Japan. He brought a lawsuit in front of Japanese court, but he did not declare that the Peruvian law should be protected, it should be applied, but he told somebody in the company outside the courtroom that Peruvian law should be applicable. Is he protected? My answer is yes. This declaration is not necessarily given in the process of litigation or in a courtroom. It can be given orally or in a quite informal manner. The important thing, however, is that the consumer has to be able to prove that he made this declaration. So what kind of proof is available? So this is the thing that the consumer should bear in mind. The third case, a very rich Peruvian person comes to Japan, and at store he bought 500 pair of shoes. The owner of the shop was very pleased, and he got an impression that this client has a very professional background. But shortly after, the shop owner received a service that he was sued in Japanese court, and the lawsuit was brought by this Peruvian client. And the lawsuit was brought with an argument that this Peruvian client was not well taking care of the consumer. So he demands the protection of the consumer law under the Peruvian law, because he found out that the applicable law to the contract was the law of one of the countries which he doesn't know. Could he be protected under the new private international law? My answer is no. The reason is because under normal circumstances, if somebody buys 500 pair of shoes, he would be most probably considered as a professional buyer. Therefore, the shop owner can expect that the contract partner is a professional, not a consumer. So, of course, if this Peruvian client could prove that from the situation of that time, it was very clear that the shop owner accepted him as a consumer, just a consumer, not as a professional buyer, then he may get the protection, but under normal circumstances, he will not get the protection. So these details you would find in Article 11 of the new law. Quickly, I will explain about the new rule on labor contract. The scheme of the protection is quite similar. I mentioned quite briefly, as I said before, even irrespective of the applicable law agreed by the parties, the employee could make a declaration that some mandatory rules of the law which has the closest connection to the labor contract shall be applied. Then what is the closest connection? In this particular case of labor contract, it is presumed that the law of the place where the labor is to be carried out according to labor contract is presumed as the law of the place which has the closest connection. So in a case where a Peruvian national is employed by a Japanese company, but to work in other countries, well, I would say the United States, for example, this employee could claim the application of the labor law in United States under this new law. Well, of course, it is just a fact. This is the factor of the presumption. So, if the employer could prove that the place of the law of other places is more, how to say, or even closer to even more closely connected to the contract, then this law might apply. But the default rule is that the law of the place where the employee works is the place which has the closest relationship to the contract. You will find the details in Article 12 of the new law. Well, the time is limited, so I could not give you the very detailed explanation to the new law, but I do hope that I could have more opportunities to explain about the Japanese private international law in the near future. Thank you very much for your attention.